Jim Kavanaugh, Douglas County Commissioner, and this is the latest in a series of meetings of our Administrative Services Committee. If you haven't signed in, please do before you leave, so we have a record of your attendance. And this is a public meeting, and so a copy of the Public Meetings Act is posted here on the wall behind me. And a record is being kept of the proceedings, and minutes will be available shortly via the Douglas County Clerk. I want to thank my colleague, Commissioner Judah, who's with us, the staff of the Douglas County Board, representatives of Douglas County Public Property, representatives of the Douglas County Public Defender's Office, Douglas County Commissioner Mark Kraft, Douglas County Clerk of the District Court John Friend, and members of the interested public. In the interest of time, we're holding a series of these hearings, so if we don't get to everybody today, this isn't the last bite of the apple that you'll have. We're trying to do today's hearing in an hour. I mentioned before some of you got here that there's a sign-in sheet. Before you leave, please sign in on the sign-in sheet. And we will try to get through the prepared testimony that we have from individuals, and then public testimony. Douglas County Board Chair Chris Rogers has joined us. We will hope that we can get through as many as possible, but you know, with time constraints, we do the best we can. The Administrative Services Committee started holding hearings on this months ago to air what we do going forward with our juvenile justice system. As you're probably aware, there have been proposals put forward, varying directions that we can go in relative to capital construction, buildings that we may acquire, structures that we may build or renovate. We're not here to talk about that so much today. There have been hearings on that, and there'll be more hearings on that. But as was pointed out in the public hearing at the Douglas County Board a week ago today, by interested citizens, and one of the reasons we hold these hearings is because we always get good ideas from the citizens, is we're talking to everybody except people involved in the system, family, children, advocates. And so what goes on in the building, and you'll hear from our leadoff testifier, whatever the building is, wherever the building is as important as whatever the building is, wherever the building is. The two principles that have guided us throughout this are the best interests of the children and the best interests of the taxpayers of Douglas County, and trying to balance those to come up with the best outcome that we can on this important issue. So, that said, we will lead off with Judge Pat McDermott, who joined us here today. And if the testifiers could come up and occupy these seats, that would be ideal. Judge McDermott began as a practicing attorney, I believe, in the Douglas County Public Defender's Office. He and I were colleagues at that point, and he ascended to the bench, initially to the separate juvenile court, and county bench, I'm sorry, and ultimately the district court. He's recently retired from that, is still a judge emeritus on call, and still sits on cases, but has a lifelong experience and interest in exactly what we're saying. And when I was quoting earlier, what goes on inside the buildings is as important as the buildings, more important than the buildings themselves. I was actually quoting the judge. So, Judge, thank you for joining us, and I'd be interested, I think we all would, in your views on what we should do going forward on this important issue.
let me just correct the record. I was a district county judge, which meant I had county jurisdiction in 11 counties of the 5th Judicial District. But I was one of those county court judges that had juvenile jurisdiction, and I focused in the juvenile area. I'm just left my tenure as a director of the National Council of Juvenile and Family Court Judges, which is the oldest judicial organization, and its mission is to train judges to help families. So I spent the last 5 years doing a lot of work in the area of juvenile justice and latest best practices. Disclose a bias, because I think any speaker should. Having looked at this whole thing 10 years ago, it seemed to me that I have a strong campus preference. For children, I like green spaces and I like low and wide. But that's a policy decision that the board has to make, and that's above my pay grade. But I do want to disclose that bias because I think it falls into the rest of the things I have to say. I also want to acknowledge that I had a chat with Tom Riley, who's been my good friend for 46 years and the public defender here, and you have no idea what a gem you have in Mr. Riley.
Know. I think we do have an idea.
But in our conversation, one thing he emphasized to me was, I don't care where they put us, I just want them to put us together. And I think that probably Mr. Klein, I've not spoken to him, would also have that preference, because it's very hard to lead a department when you have people spread out in a lot of locales and you're not there to observe them on a daily basis. That's a tough management style. So I do acknowledge that Tom has a legitimate request there. And when we get to my last issue, we'll talk a little bit more about that and how I think technology can assist in overcoming some of the barriers there. My whole theme is this should be a family-centered judicial center. Not one built for the convenience of judges and lawyers, but one built for the families that are going to be served by that facility. And there are certain components to that, wherever it is, that are important. The very first one, provide free parking. These families are in poverty. It doesn't seem like a lot to you and me to come down and pay $5 to park in a lot downtown, but some of those families are making choices about that $5, and I think having a free parking arrangement, as an example, when I sat here, which I did a lot when Judge McGrath was ill, I came in and covered with the late Jerry Rouse, his docket. We used to park in the lot there at 20th and Harney. And the first thing I did coming in the morning was go to the clerk's office and get my get-out-of-jail-free card, which meant I could put in the card and then put in the one that didn't make me pay for the parking, since I was a visiting judge. I think some mechanism like that, hopefully simpler, for families is important. The facility has to have family and child-friendly spaces. And there's a lot of science on that now, and I think maybe the leaders would be the American Association of Pediatric Physicians, who have worked for years to design their offices so that children who are afraid of doctors and getting their shots and that sort of thing come into a place that is very child-friendly. Color is important, size of chairs is important, those kinds of things that can make a child feel less apprehensive. And it's important to think of family units, because we focus on the parent and maybe the child who is in trouble if it's a juvenile justice case, or the parents themselves. And we expect very young children to sit in the second row of the courtroom and be very quiet. Well, those children are really afraid, almost as afraid, maybe more, than the subject of the hearing, because that's their big brother or their big sister, and they're afraid what's going to happen to them. So we need to be thinking about people who walk in, because trauma can visit them just as readily as it can the child who is the subject matter. There needs to be safe places for families to wait. There are many of these cases, particularly in the abuse cases, where there is a companion or history of domestic violence. These families have to have a place to be when everybody has to be in the courtroom, including the person who abused them, whether now or in history. And it's important for them to have a place where they feel safe to wait for their turn in court. There needs to be places adequate for the lawyers to meet with their clients. The reality is, again, that it's very difficult for these people to come down and have appointments at the public defender's office or at the offices surrounding the courthouse for the same poverty barriers that I mentioned earlier. So it's important that lawyers can arrange to meet their clients before hearings and have adequate places where it's quiet, where they can be confidential and speak to their clients. Lastly, I want to address a little bit the youth center, because I think that's critical. The thought of putting kids in a high-rise building is just the antithesis of what I know about children and how they function in facilities. These kids need serene surroundings, if I can use that term, where they have a chance to reflect on what they've done, where there's some peacefulness around them, because it's the only way that kids have a chance to do that. Now that raises an issue for Tom Riley's position if he wants everybody together. And how is he going to have lawyers out at the youth center to do time-sensitive detention hearings and things of that nature? For 15 of the 20 years I was on the bench, I did prisoners and kids in placement by video conferencing. The commissioners in Colfax County, where I did most of this work, kept upgrading my system, so by the time I left, we had a very sophisticated high-definition system, extremely reliable. And I could have kids from Madison appear, but there was always that problem: how do their lawyers get a chance to talk to them? We used to give the lawyers the courtroom ahead of detention hearings so they could speak confidentially to their client. We then put in what they call the codex, which was a separate communication device that permitted them to go to the conference room and have privacy to adjust their clients. And I think one very, very simple solution, because I know that when the courtroom was built down at the detention center, the public defender's office had some real reservations about that phone that they could pick up to talk to their client. I share those because I've seen lawyers pick up that phone and it comes blaring through the speaker in my courtroom for all the world to hear, because that was extremely unreliable. But you know, unless you're the NSA, practically nobody can intercept a cell phone call. So the solution was to have a cell phone for the lawyer and a cell phone available to the child so they could communicate by a cell phone. Nobody's intercepting that call. And it does give an ability for the lawyer to give some guidance to his client with an assurance of confidentiality. I did a lot of evidentiary hearings by video conferencing. I don't think the judges here are comfortable with that yet. I was a child of necessity. I'm an outlier. I'm an old duffer that's not afraid to change. And I really embraced the video conferencing because I'm a person who thinks the video conferencing virtual courtroom is something that the young lawyers of today will see in their lifetime. Those are the essentials that I think need to be in any facilities. And there was a resolution adopted by the National Council of Juvenile and Family Court Judges at their annual meeting in Denver that is entitled Family-Centered Practice. And that's where I got these concepts from. I'll be happy to provide Commissioner Kavanaugh with a copy of that resolution, because it does help you understand that there's a lot of people in academia, there are a lot of people in the law studying this. Unfortunately, the sociologists have their silo, the psychologists have their silo, the pediatricians have their silo, and the lawyers and the judges have their own silos. We got to get a lot more collaborative. We got to think horizontally rather than vertically, if we are really going to take the best of the science, integrate it into a really worthwhile facility, you contemplate making a huge public investment here. And it's long overdue. I believe that this is a project that needs doing. But you have an enormous opportunity to do a lot right now with this new facility, wherever it is, to make it really cutting edge, a facility that people from other cities will come to look to see how to do it right. And I hope you seize that opportunity and build that kind of a facility.
Thank you, Judge.
That's all I've got.
I appreciate it. If you stay with us, we're going to get to public comments, and there might be a question later on, but
Sure. I don't have any place to be. I'm still retired.
Thank you very much.
Okay.
We've been joined by the director and staff of the Douglas County Youth Center, and thanks for coming. Our next presenter is an advocate, active in the field, an attorney, and recognized expert in the area of juvenile law and juvenile justice in Nebraska and nationally, Joy Suter. Joy has practiced in this area for years, if not decades. I'm not sure how.
1 decade.
1 decade. And currently is active both as an advocate and as a resource on juvenile justice. And we're happy to have you here with us today, Joy. Thank you.
Thank you. I appreciate the opportunity to be here, and I'm grateful for the interest of the county and also of community members, because whether people's interest in this facility, whatever it may be, one facility or two, whether that interest is based on care and concern for kids, care and concern for court practices, care and concern for your taxpayer dollars, is an important issue. And so, no matter how you came to the table and to awareness of these issues, I'm grateful. And whatever the result is, I hope that everyone continues to be interested and continue to care about how, as a county, we treat our kids that come to the attention of the courts. A couple of clarifications that I think are important, because words are so important and they're so powerful and they have great meaning. And when we use words maybe inappropriately or too broadly, that confuses people, and it confuses, I think, stakeholders, and it's best to get things kind of cleared up. Judge McDermott, when he talks about having a family-centered judicial center, that's an important point that I think we all need to be aware of, is that we've talked about this, the entire project has been called a juvenile justice center. But juvenile justice historically refers to kids only, delinquency cases, kids that are breaking the law, whether as status offenders, not going to school, or committing law violations. But the juvenile court also handles child welfare cases, instances of abuse and neglect. They handle guardianships and custody issues for kids who are wards of the state. So it's not just juvenile justice. We're talking about juvenile matters, and every single juvenile matter. I only have 10 years experience in this realm. Judge McDermott has more. But I would guess he would agree with me that even when a child, a delinquent child, comes to the attention of the court, the issue isn't just with that child, it's with that child's family. Whether it's parental supervision, community structure and resources, access to resources, things like that. So this is a family court situation, whether we're dealing with one 16-year-old child or a family case with 7 children of abuse, neglect, or dependency. And I want that to be known, that we're not just talking about kids who get in trouble, but families, and making everything more accessible, friendly, comfortable, productive for families who come to our attention. The second thing that I want to always make sure people know is that children have rights. And children have the right to a lawyer. And that lawyer's job is to act as the expressed interest advocate for that child and to ensure that what that child wants is what happens in that court case. That can be very difficult, but what that means is sometimes a 12-year-old is my boss. And I do what that 12-year-old wants me to do. Of course, I educate and I counsel and I do all of these different things that I'm required to do as an attorney. But ultimately, what my client wants is how I proceed. And I do that in the legally appropriate way at the legally appropriate time. What affects that and how the court rules and how the court proceeds is what's in the best interests of the child. This phrase gets thrown around quite a bit. It's the best interest of the child who is sitting in front of the court at that particular moment in time. What is so difficult about juvenile cases, whether they are child welfare cases or juvenile justice cases, is that you could have two children with similar charges, but their cases are handled completely differently. That's because each individual child has individual needs and will respond to directives and court orders in a different way. Rehabilitation is the primary theme. It's the only theme in our juvenile justice cases in this state. The standards and the practices and the intention of juvenile court in the state of Nebraska has to do with rehabilitation. We're not a punitive state. Kids don't get sent to the youth center to serve time or to finish a sentence. The youth center is utilized as a stopgap between placements for children. And a placement is considered to be a place where a child is receiving rehabilitative services. That placement can be at home, it can be a group home, it could be a youth rehabilitation and treatment center. But placements, Douglas County Youth Center is not a placement for purposes of how we do business, and by law it can't be. So that's also an important thing to note. We also need to know and remember that every child who comes to the attention of the court and has an open juvenile justice case for delinquency offenses, which would be a law violation, or status offenders, every single child runs the risk of being removed from their home, period. Every single child, whether it's a truancy case, failing to go to school, each child runs the risk of being removed from their home. Now, status offenders by law are not able to be placed at the Douglas County Youth Center. Only delinquency cases can, so violations of crimes that are actions that are crimes no matter the age of the perpetrator. That's a delinquency act if the child is under the age of 18. But kids that are placed at DCYC, not all of them only go there just once. There are a handful of kids who have several visits there throughout the life of their case. And the life of their case, what does that mean? Well, when our focus is rehabilitation, when is a child rehabilitated? I had a parent ask me once, when will my child be fixed? When will my child be rehabilitated? If I could answer that question, I'd win a Nobel Prize. It depends on that child. But the nature of our laws and the nature of how we do things and the focus being rehabilitation means that child could be rehabilitated in the eyes of the court in 6 months, in 3 months, in 1 month, or until they're 19 years old. And in the course of my 10-year career, I have represented more than one child for more than 5 years. So, and sometimes 7 and sometimes 8. And so we're in a system that really the only terminus is the age of majority of 19. And so during the life of that case, at any time, if the court determines there's a basis for detention, that child can be going in and out of detention, in and out of placements, in and out of shelters, in and out of different facilities. That's important to remember because when we talk about average length of stay, it's also not just one child, that's all they're ever there for. It also, detention, the majority of those kids, and I don't have the data in front of me, I've asked the probation office to compile it so that it can be available, but the majority of the kids that are at DCYC are not going immediately back home. The majority at any given time, I believe, are waiting for that next placement, which typically is a higher level of care. So when we talk about seamless transitions, how can we not harm these kids while they're at DCYC? What how do we make sure that we're not hurting more? Within that facility, there has to be adequate access to mental health services. There needs to be adequate educational services. There need to be adequate medical services. And within the past 5 years, I believe, the Douglas County Youth Center has done a phenomenal job, and probably longer, Mr. Alexander can correct me, but with getting more services on site. And that's been a great thing. But we still have a facility that by its design is a little bit outdated, and by its design is not trauma informed. And what we know about the kids who are spending time at the Douglas County Youth Center, the majority have mental health diagnoses, the majority, or close to, have individualized education programs, IEPs. Many of them don't have family members that are able to visit or can visit frequently due to transportation constraints, work schedules, childcare issues, and the like. DCYC takes great strides to make accommodations for siblings to visit, but that can't always happen. And so, going back to those initial comments that I made and what Judge McDermott said about family, when we are trying to disrupt the lives of these children as much as possible, we have to make sure that decisions are being made that it is truly better for society, for this child, to not be in school, to not be with their family, to not be participating in extracurricular activities, to not be going to work, to not hang out with their friends, but to actually be detained. I say that as a foray into questions about bed size and population at Douglas County Youth Center. How have we gotten to a point where in the last 10 years the average daily population has been cut in half? For the past 6 or so years, our legislature has been doing solid focused work on improving, requiring, mandating access to alternatives to detention. These come in the forms of shelter placement, which is another temporary placement for a child while they're waiting a permanent placement where they can have access to rehabilitative services. But we have a scheme of alternatives to detention. And those are legislatively mandated, and then state or individual jurisdictions have the ability to develop more of those. And the state has done a great job providing funding so that formerly more structured alternative services can expand into a more alternative sort of a setting that doesn't require detention. We also have implemented over the last 6 years as a state screening tools that are used by the probation intake staff so that when kids hit the doors of the youth center, they're scoring out, or into detention, and they're focusing on diverting away from the youth center as many kids as possible. So that's one of the ways that we've cut our average daily population down. In July of 2019, July 1st, we have new provisions of the law that will go into effect, which will also severely decrease the number of children, the parameters of a particular child's situation that will be able to be detained. July 1st, 2019, the current standard for detention is that if a child is found to be a danger of risk to themselves, others, the property of others, or a flight risk from the jurisdiction. That's it. If a judge determines that to be true, a child can be detained. As of July 1st, 2019, the new law will go into effect that says that physical safety of persons in the community would be seriously threatened, and detention is necessary to secure the presence of a juvenile at the next hearing if there has been evidence, demonstrable evidence, of a willful record to failure to appear at court. And then it explicitly states that children 12 or under cannot be placed in detention. Detention is not appropriate. It cannot happen to allow a parent or a guardian to avoid their legal parental responsibilities. It cannot be used to punish, treat, or rehabilitate juveniles. It cannot be used to permit more convenient administrative access to justice. It cannot be used to facilitate further interrogation or investigation, and it cannot be used due to a lack of a more appropriate facility. We have detention hearings up in juvenile court every day at 2 o'clock. And that standard right now is the child a danger to themselves, others, the property of others, or a flight risk. And a party might say, Judge, we think this child should go to a shelter, but we don't have any beds available. Now, kids then go to the youth center until a bed becomes available. What the new law will do on July 1st is say it's not an option. If the child is eligible for an alternative to detention, just because one's not available doesn't mean they get an automatic ticket into detention. What that does then is shift the burden onto probation, it shifts the burden onto community agencies, it shifts the burden onto every one of us in this room to make sure that we have these alternatives available so that we're not detaining children. This new law will impact our population at DCYC.
Joy, I'm gonna
Yeah.
have to ask you to maybe sum up.
Sure. So that's going to be a great effort. That's going to be a great change that will reduce our population. As far as other things that we need to do as a community to support rehabilitative efforts is to recognize that we are dealing with children. I do want to talk about video conferencing. There are many states, bar associations that have come out stating that using video conferencing for hearings for juveniles is a violation of due process. Due process meaning access to my attorney, access to the facilities. We don't use right now video conferencing in Douglas County for adults for court hearings. I don't see why we would want to do that for a 13-year-old. My clients are very young, they don't understand a lot of things that are going on, despite my best efforts to help them understand. And being able to sit next to my client, to offer a reassuring hand on the shoulder, to be able to lean in and answer a question, that's necessary. And I don't believe that video conferencing is appropriate when we're talking about specific hearings. You know, I understand Judge McDermott's went out in his jurisdiction when we had a lot of transportation issues, multiple hours to transport. We don't have that issue here. We also have a history in Douglas County of moving court to where detainees are. Courtroom 50 is the courtroom that's at Douglas County Corrections. That's where bond settings are held for inmates there, because at one point the county determined that it made more sense to put court there rather than transport the inmates from corrections to the courthouse.
I'm sorry.
Whatever, I just,
Yeah,
thank
just-
you. And in summary, I just want us to truly remember that we are dealing with children and families, and the facility does make a difference, and the location makes a difference, and access to counsel and meeting, all of those things make differences. And we are doing better, but we can always do better, and progress is never done. Thank you.
If you could just stay there for a second, and
Sure.
I'd like to ask Judge McDermott to participate as well. If any of my colleagues on the board have questions, comments, whatever, of these two witnesses from the judiciary legal community, I'd like to kind of pivot right now and allow that opportunity before we proceed with other witnesses. So Chairman Rogers or Commissioner Duda, Commissioner Kraft, any questions you might have?
No, I want to thank them for their testimony. I just want to note, I think all their points was great, and the points have been talked about for the last 8 years in various settings. I think to note to the judge's point, there is, to the judge's point, there has been over the last 8 years a series of actions and things that have put it to this point. And the one thing to note is in 2015, we did a trauma study of the court. And so just to note everything he's saying is definitely correct. That trauma study noted things that were there that need to be changed. And I think all of that was brought into consideration to bring us to the point that we're at now.
You?
The trauma of transporting the child from a remote location in shackles to the courthouse. If we were to do dual location, how do we handle that? We can't unless we can video conferencing, and I don't believe in video conferencing for the same reasons you suggested. Body language, the nuances, the human touch. That human touch is so invaluable. Put your hand on somebody's shoulder or back, pat them or rub it. It's so calming. And you can't do that on the video. So I agree with that. Now, if we have a perfect world, which we don't, unfortunately, what we've envisioned, I'm not 100% satisfied with it. I don't like the dormitories. The child needs a place to go and cry and be by himself and not be embarrassed by other people crying with him. The child needs time alone where it's just quiet and just think, because he may have never had that at home. But it doesn't need to be a jail cell where the first night and the door goes clank and the kid cries all night, but the next day it's a badge of courage. That's the worst part of what we, not the worst part, but a really bad part of what we have now. The outdoor campus is great, and we've designed, if we go through with the whole thing, we might not do it all at once. We've designed an outdoor courtyard. Now, it may not be big enough, but it's a heck of a lot better than what we have. It may not be ideal. So, any comments on what I just said?
I'm sorry, Judge?
I apologize, thank you.
I didn't explain how all of the video conferencing worked, but to council's point, most of my people were in Columbus, about 25 miles away. I deliberately appointed attorneys in Columbus who could go out to the detention facility and appear in person in the studio with their clients. And that overcame exactly what she was talking about, which I think is important, that personal contact. So I think there are ways of doing that, but it does put an extra burden on council to have to go out to the youth center, or you copy the model from the Douglas County Corrections and you put a courtroom and the duty judge goes out to that courtroom and does those hearings right there at the youth center. Those are alternatives, but the personal contact with counsel we tried to provide for. My only exception was a kid in detention at Madison when I was in David City. That was nearly 80 miles. And I wasn't putting them out in the wintertime on those two-lane highways. So we would make another accommodation.
Judge, to Commissioner Kraft's point of the campus versus the cell block solutions that we face today, nothing's perfect, and it doesn't look like we'll get a perfect solution to this, but best practices, if we're focusing on the kids, I think you mentioned earlier you have a preference relative to that. He has asked some questions about the shackling, transporting thing, contributing to that. You have views on that?
Strong views. The National Council absolutely came down against shackling in any case. I did not permit children to be shackled who were coming to my courtroom. I had no control over the private contractors who transported children, and some of them did shackling. I was not in a position to order the county not to use those. But no child ever walked into my courtroom in shackles. For that matter, I discouraged adults walking in. It is horribly traumatizing to the family to see their 14-year-old wearing enough iron to start his own forge. So shackling is now statutorily prohibited in Nebraska, and I was a part of that effort to prohibit shackling of children.
In the court.
In the courtroom. It's hugely traumatic.
In your experience, the transport portion of this could be without shackles. I mean, has been without shackles, would be possible
The
without
private
shackles.
contractors believe they have to shackle them for the safety of the drivers and the child, which I never agreed with. My main juvenile transport officer was a deputy sheriff. He put the kids up in the front seat with him. They chatted. He used to take them through McDonald's because that was kind of a treat going on back up to Madison if they had to continue in detention. But those kids never gave him any trouble. because he was considerate of them as a human being. And if we always do that, remember these people, even if they make mistakes, are human beings, and we give them the respect we would demand as human beings, a lot of the difficulties go away. But it's not perfect.
And I agree with that.
Counselor, you had something on this?
Yeah, just to clarify, and thank you for that, the current state of the law is that children cannot be shackled up in court. And so what happens now is they're transported from Douglas County Youth Center, they're cuffed, and then down, there's a chain down to their waist and then to their ankles, brought up to a holding cell, taken through the hallway on the 6th floor, and then the chains are released prior to entering the courtroom, or in the courtroom so long as the judge hasn't come into the courtroom. As far as the transportation issue, I think it's unsafe. If we have a child that's shackled in a vehicle and there's an accident, or, you know, and kids are transported out to youth rehabilitation and treatment centers in shackles, and that's a more than an hour drive. I believe that in 2015, and I'm sure the judge can fill in my deficit here, but I believe that part of the compromise for that law being passed, for there not being shackles in the courtroom, was that the no shackling would still be eligible, be applicable to transfer.
Well, I'm sorry, clarify that,
Is,
because,
meaning, am I right, Judge, that when that bill was introduced, it included no shackling, period?
well,
And
that's,
so the compromise became, all right, well, we'll just say no shackles in the courtroom,
right.
removing language from the bill that would have said no shackling of juveniles, period,
Right,
ever.
because
Right.
to be clear, at least under the current arrangement, the sheriff's office, it's gonna take a change in state law because they're the ones that make that decision, not the
Right.
county board or anybody else, the
Correct.
judges, it's the sheriff that makes that decision.
So,
Chairman
so,
Rogers, I think you had a question.
That was a compromise that came out of it, and Judge, you know, I want to thank you for your work, but Joy mentioned that the statute change, that's LB 1112. And LB 1112 is a culmination of 8 years of work by people like the judge and a whole lot of state senators that have come along and continued it. Yeah, there was a tweak to that law to make that compromise for shackles, but everybody knows it's not ideal. They shouldn't be shackled at all, but it's the compromise that you happen with law. To that point, what I'm saying is that LB 1112 is a recent development. Over the last 10 to 8 years, there's a group of us that get together at the state every year to talk about this. There's a group right now meeting to talk about the ramifications of 1112. Judges are talking about it. The states need to do it. That's why they gave it the year. I guess the point that I'm making is that a lot of the changes that have happened to the state have been driven by this county. It's kind of like the education mantra. If Texas wants something in the school book, damn near the whole country is going to get it because Texas is so big, you got to accommodate them. And if the county, if something changes in Douglas County, the complaint from a lot of the smaller places is it rolls down to us, and it is. So the county has pushed a lot of this. The county pushed it through JDI, which was the first site, and now pretty much all those statutes that happen and change are based off JDI principles. So the point I'm making is that machinery is rolling, and it's not going to reverse back. The state has continued to go there, they've continued to work with it, and they've continued to drive that to their credit and to the credit of the leadership of probation and Judge Havoc. And so there's a movement going with it, it's continued, and a lot of things are continuing to be worked on and will be to make sure that a lot of this best practice has been codified. So at some point, the shackle piece is going to be brought up. It's just not the right time, but people know we needed to get it in to make it appropriate.
Thank you. Mr. Friend, I don't know if you had anything to ask.
Just here to learn. Thank you.
And thank you. We're going to move on to the next testifier that we have, which is the Director of Omaha, or Operation Youth Success, Janie Pankuk. I'm sorry. Jay. Two E's got me, Jay. Sorry.
Janae.
Janae.
It's my parents' fault.
Oh, I've got a son with the same problem. He's an Irish name. Thank you. Would you give your correct name for the record?
Janae Francis with Operation New Success.
Thanks for being here today. I know that you and OYS do a lot of advocacy work in the community, and that's what this hearing is kind of focusing on, is what can we do better, what are we doing good. We've heard some of the things that we've got that are working, we've heard some of the things that we've got that we're struggling with, and in the brief time that we have, you could give us your views on best practices and what should we do differently.
Sure. Well, thank you for the opportunity. I think most people have touched on this. I think family and centered focus is where we all want to be as a community, and that's what I hear from the commissioners and powers that be. So I would like to refer to the Chin report. First of all, this was, Operation Youth Success was in an infancy stage, and we are a public-private partnership that has now come about in the last couple years here. And when you look at the Chin report, the key findings, the first three on there, in collaboration with the Juvenile Detention's Alternative Initiative, referred to as JDI, that has been in the county for the last few years, about seven years, maybe going on 8 years, that these first three findings or key recommendations from the Chin report are actually being addressed between Juvenile Detention's Alternative Initiative and OYS, which is there is a overall mission and vision statement for juvenile justice within Douglas County. There also is ongoing systematic dialogue with coordinating counsel with juvenile justice system, and that includes the courts, probation, Douglas County Correctional Youth Facility, defense, prosecution, schools, community organization, advocate, and service providers. So as far as what best practices are, I would lean into those experts. We coordinate those. We do not have a in-house expert, I would say, but we lean into the experts from all those various touch points and find out, what they see as the expertise. And then also, especially, have youth and families that are touched by the system, their input into what are best practices, what worked well for them, what didn't work well for them. And that's what we bring to the table, is that collaborative effort. The last piece would be the data collection, which is spot on about it being so many different, as we've talked about and has been surfaced in this and other hearings, is the complexity of the system, especially when you add in child welfare aspects. And youth impact is a nationally recognized model that's here in Douglas County regarding those crossover youth that are both in child welfare and in juvenile justice aspects of the system. So they're involved in JDI and OYS efforts. So again, they're the experts. They're nationally recognized. So as we talk about what we want the center or centers or whatever it looks like to be, we have the expertise in the county. And I appreciate being involved and having this opportunity. So we're working on those top three pieces there.
Well, thank you. Just for everybody's edification, the Chin report, which is available here and online, came out in January of 2018, commissioned by the Building Commission. Top three findings that we've just heard about are: there is no overall vision and mission statement for the Juvenile Justice Center in Douglas County. That's the top finding. Number two is there is no ongoing and systematic dialogue with coordinating counsel to review the juvenile justice system on a routine basis. That's number two. And the third one is data collection and reporting are not consistent and accurate to guide decision making. These things, and I've read this thing over and over, and I'd recommend that everybody did, really tell me that as far as we've come, we've got farther to go. And it's time to take a deep breath to address. Those are just the top three of, I think there are 8 or 10 more findings of deficiencies as of January of this year. We paid for this study. We asked them to tell us. They came in, they gave us their best estimate. And all of this seems to say, you know, you do some things good. These are major concerns that need to be addressed and haven't been solved since January of 2018. Thanks for bringing them up, because I think they should guide us going forward relative to, let's move in a deliberate, thoughtful way and take our time to address these and the others. I would recommend everybody get a copy of the Chin report and look at page 78. Chairman Rogers.
To your point, one and two, she did a debrief. 1 and 2 are not fair to some extent. That's a point that was made, but 1 and 2 have been constantly addressed. She was not aware of information that was there for that. So 1 and 2, I think, are being addressed, and it's a constant process. 3 is fair, because there's a lot of silos of data that we have around in certain aspects. The one we use right now, the QRS, which is prescribed by JDAI, that gives us certain numbers that drive, that is what we generally use, but there's other data around in the JAG and DCYC. That's legit, and there's work that's being done now to try to work on some constant definitions. Matter of fact, when she came, we were not staffed up with the data people, but there was work was done, and it needed to be continued. So the data person that's associated with OYS now is, quite frankly, in the process of working with .com to break everything down to its basis and its numbers. So 3 is fair. 1 and 2 is a continual process, and we had a conversation about that in the debrief. I think, as Joy said, and to quote her, I think it's fair to say, you know, we can always do better when progress has been made, but there's progress being made on 1 and 2.
Thank you. Any other commissioner comments, questions? Okay. Thank you, and we're running tight on time, so stay with us. We'll have a kind of a public comment time here. I want to take this last portion to thank the folks who have come. We have one more individual from the Public Defender's Office, Lauren Wallig, who would take time out of her busy schedule, and as a former public defender, I know how busy that can be, to share with us, if you could, briefly, your observation on this important topic.
Sure. Good morning. My name is Lauren Wallig. I'm an attorney with the Public Defender's Office. Primarily, I work in juvenile court in our juvenile division. I won't take much time since it looks like we're running out. I echo most of the points here made by Joy. I think she pointed out a lot of the key developments that JDI and OYS have, as well as our legislature have done with addressing some of the needs in juvenile court. I think that change in the legislation next year is going to be huge as far as detention numbers. We have had a lot of improvements with alternative to detentions. I believe our office's numbers for detention have decreased recently. There is still work to be done, though. Specifically, we have a lot of youth coming in for some violent offenses as well as those gun offenses. Those individuals are not able to be placed on certain alternatives to detention, like the home program. Certain shelters also will not take them. That is a group of individuals that I think is sometimes lost when we talk about these youth.
Excuse me, are you talking about juveniles facing adult charges?
Nope.
Okay, thank you.
Nope.
All right.
There's those also, but I'm talking specifically about those youth coming through our juvenile system
Right.
with those charges. Another thing we have that I know has been talked about in some of these other meetings is the lag time with getting evaluations complete and the number of evaluators that we have able to be accessed for our youth. Again, another thing that we've done well, or that the courts have done well, is pushed this ecological system and the MST system through Boys Town. Those are great in-home services for these families, they're wraparound services. MST is multi-systematic therapy. Yes, it's a form of this like individual family. Yep, of course. The problem with those is currently I want to say there's a wait list of around 3 weeks. So I have youth in shelters or in the youth center that are waiting to go home, but MST has to be in place before they can go home. So they're doing well in the shelter, they could go home, but the courts are saying, I don't want to do that until we get the service ready. And right now, we're having to wait weeks for that to happen. So those are youth that are just kind of sitting, waiting to get these services in place. Another part of that is getting these evaluations done. We have a lot of youth that are being ordered to complete substance abuse evaluations, mental health evaluations, co-occurring, which is the dual diagnosis, as well as full-scale psychiatric evaluations. Those things are limited just based on the numbers of providers we have, the numbers of providers that are able to go to the youth center or to shelters. Youth center has, I know, added people to the staff, which is great and it has helped us. But currently we have people that are waiting even 30 to 45 days to even get in for their eval, and then we have to wait an additional about 30 days to get those back. And sometimes the courts are hesitant to let these youth go home before they have the results of those evaluations back, because we don't know the level of care needed, we don't know what that means for placement as well as treatment options. So I think those are things specifically that I see that could be addressed and could help us move some things along.
Thank you. You know, this is something, it's interesting how things overlap. That came up at yesterday's Douglas County Health Center Board of Trustees meeting relative to the provision of mental health care. And, you know, we discovered in the course of this that the lapse on evaluations, mental health evaluations, can be months, and it can indirectly contribute to lengthened stays of kids in the youth center, which is bad. And so we discussed, and this is just a very preliminary discussion about how can we beef up the healthcare providers, and you point out systematic lack of resources contributing to delays in a wide variety of care providers. This is one. Because we're not going to get help from the state. I mean, there's a bottleneck in the state. There's been a bottleneck in the state. There's going to be a bottleneck in the state, and they don't appear inclined to dedicate any resources. So the discussion came back to what can we do for ourselves? What can Douglas County do for Douglas County kids? And you bring up more than just the mental health one, which contributes to the stays of kids in our youth center, which is one of the findings not only of the Chin report, but throughout this, that I think we have an average length of stay of 50 days or thereabouts. And that's over the national average and longer than we want. I wouldn't want my kid someplace outside of school, outside of home for 50 days. I don't think too many people would. So that's important, and I think those delays are something that we should really take into consideration, because at the end of the day, it doesn't look like anybody's coming to help us. It looks like we're gonna have to help ourselves on this, and there are kids, and so we're gonna have to dedicate some of our resources to do this. But thanks for bringing that up. I don't know if any of my colleagues have.
Yeah, go ahead, see, you had one, go.
Do you see a way of expediting the MST analysis? Is it lack of professionals? What is the cause of that?
Mine would purely be an assumption. My guess would be that there's a lack of professionals that they have on their staff, but I don't know. I don't know if Joy could speak to that more.
I think there's two issues, Commissioner. One is that we have a tendency in juvenile court here when there is a new option that's available, a new service, to flood it. Because it's something new and we want it to work and we're desperate for it to work and to try something new. And sometimes we tend to flood services without stepping in to ensure that X is the right service for child Y. So that being said, MST is a relatively new service that's available for families, and we may be over-referring to it without necessarily determining if it's the right fit for the right child, but also we have a lack of I think, you know, we don't have a bevy of providers that offer that service. And so there truly is a desire to do better. But we just really lack a lot of community-based resources for kids that are system involved.
Thank you. Chairman Rogers.
To their points, I think this is just a hard nut to crack because of capacity. And there was a meeting held in July that was facilitated by Commissioner Borges and myself with Dr. Carla Pope. She's an interim chair of psychology at Creighton. She's done some work at, I think, DCYC at one point. I had a follow-up conversation with her, and she thinks that there's some more that we can do to some degree. Her hope is if if things speed up and she becomes permanent, some things have changed at CHI. She thinks there's some more that can be done in that evaluation piece. So I hope is to be able to have this follow-up meeting with her and see what we can do to progress on that.
Thank you. We're gonna pivot again here, and thank you for your testimony. This is great. The purpose of the overall strategy for the meeting was children, family, and advocates, and I think we've had great input from advocates and representatives of the children involved in the system. I want to take this opportunity to call on any of the family members or former youth involved in the system. It's impossible to have a kid who's currently involved in the juvenile justice system to come and testify at a hearing like this. It's legally not doable. But people who have gone through the system exist in our community, and we've heard from some of them at our board hearing. I just wanted to ask, before we get into the full public hearing, if there's any family members, moms, dads, brothers, sisters, or former youth who have been through the system that would like to come up and share their views with us. Thank you. We do have a full array of folks. It's 11:01 now, and we're going to try to bring this in an hour. That's not going to happen, but we can probably bring it in an hour 15. If you have a comment that you could give us in maybe a minute or two, would you like to share those with us? Now would be the time to come up and do that. Is there anyone that would like to share their comments with us?
A minute or two?
Sorry?
Say a minute?
A minute or two. We're at 11:01 now. And this isn't the last hearing that you're going to have the opportunity, but I know that Ben Salazar, we've spoken before, has some views on this. And Ben, if you'd like to come over here. And
Takes me a minute just to clear my throat.
absolutely.
Hi, my name is Ben Salazar. I'm not an elected official, nor even an appointed official, and I don't work for any particular agency or government entity, but I'm glad to be here. Some of you may know that I'm a Chicano advocate. I've been an advocate for Latinos, Chicanos, Mexicanos for nearly 50 years. Actually, it is 50 years this year that I started my advocacy for Latinos right out of military service when, having grown up in Scotts Bluff, as a Chicano living in that part of western Nebraska, I always felt this Jim Crow attitudes prevalent in my community, and that was a great bother to me psychologically, and not only myself but to other members of my community. When I left service, I felt that there was a need for another voice, perhaps even a voice in my community, and I started my advocacy then and continued at the University of Nebraska. Oftentimes I found myself as the only Chicano in my classroom in high school. That continued at the university, where I was oftentimes the only Chicano or Latino in my classes. And even to this day, as I look around, finding myself as the only Latino voice is not novel to me, but because of the size of my community here in Omaha, I continue my advocacy on a more fervent level. I have let it be known that the Chin study, as it's being referred to, it was sent to me by a colleague for my review, my opinions. And as I opened the first few pages, I realized what she was alerting me to, and that was the lack of any Latinos or Spanish surname individuals involved in any way in this study, either at the advisory board level or as members of the interview list. And I thought, how in the heck can this happen once again in a city this size with 50-some thousand Latino residents? Not only did I find that appalling, but I thought this has got to be unlawful as well. There's got to be some violation of local, county, federal laws, perhaps the 1964 Civil Rights Law. I thought there's got to be money being spent from the get-go on this study, and why there is no Latino input at any level. I think has got to be prohibited. So I filed off a complaint. I think it was the other day that I sent it out to the Board of Commissioners, the City Council, and others, and said, you can't allow this to continue in this fashion. There've got to be Latino advocates, Latino voices at every stage, because otherwise we have what's comparable to the fruit of the poisonous tree, Judge. And by the way, Judge, thank you for your comments. It's a great benefit to hear someone with such clarity and insight on issues such as this. I don't have a lot of participation directly in the judicial system anymore. I'm an outsider, but I do have a lot of heavy interest in what happens to my community with respect to entree into the judicial system, and especially our youth. So I'm here to say I'm learning. A lot of terms I'm not familiar with, but I'm here to learn more about what happens to juveniles. I think there's a need for cultural awareness of Latinos and families and their children at every stage in the evolution of this program and this project. So I'm here to say that while I'm not employed directly or indirectly in any fashion, certainly I want to be involved in some way to provide the benefit of my experiences as an advocate for Latinos. So I'm glad to be here.
Thank you, appreciate it. And, as promised, here's your copy of the agenda.
Thank you very much.
Is there anyone else? We're at 11:06, so I'm not soliciting anybody in this program any more than necessary, but if there is anyone, oh,
Ben,
John Ryan.
Ben, I hear you. Let me know you can always have more voices, and that point is well taken. But there is one Latino participating on it. Now, being African American, I know what you're saying. So one doesn't mean that. I hear you. That wasn't the intent, because the point is just because of the makeup of the system, which is something being taught now. There's not a lot of people of color in the system. So your point is fair, that there is one Latino listed on that deal, and I agree your point.
Thank you. If not, we will conclude today's hearing. This is, like I said, one in a series. This is going to be the last, and hopefully everyone that we have, as I think everybody will agree on this one, shows us a new area that we could go into and study. We need to do this deliberately. We need to do it over time. We need to do it right, not quick. So thanks, everybody, for being here today. You've helped us immensely. Thank you. We are adjourned.